only mode.
Hello and welcome to this ACEDS webinar, ACA Reporting and the HIPAA Omnibus Final Rule, Privacy and Security Requirements Doubly Strengthened, presented by ZyLAB. I'm your host, Robert Hilton of ACEDS, and in a moment I'm going to introduce our three expert speakers, but first I have a couple of quick announcements. For those of you who aren't familiar with us, we are a members-only association that provides training, resources, and networking to the eDiscovery community. We also offer the Certified eDiscovery Specialist credential, which is held by hundreds of professionals across the Americas, Europe, and Asia. You can join today and start receiving a number of benefits exclusive to our members, including news content, on-demand web seminars, our Bits and Bytes newsletter, and discounts on certification and next year's conference. If you go to the next slide, mark your calendars. You have, if you haven't already, ACEDS is holding its inaugural Corporate eDiscovery Summit on October 10th and 11th in San Francisco. Attendees will hear from experts from leading corporations like Google, Intel, and Dell. Also, you can meet one of our speakers, Mary Mack. I think she'll be there. Panels will also tackle pressing challenges like reducing the cost of big data, information security, and defensible deletion. If you can't make it out to San Francisco, you can attend online from the comfort of your home or office. So if you're interested, please visit corporateediscoverysummit.com. All right, as I said, we have three great speakers for you today. The first is Ken Rashbaum, an attorney and principal at Rashbaum Associates in Manhattan. Ken has been the trusted advisor to multiple healthcare providers, health plans, and multinational corporations on information governance and its compliance with federal, state, and international law. Previously, he served as partner and co-chair of the eDiscovery Compliance and Data Management Practice Group of AmLaw 100 law firm Sedgwick, Deterrett, Moran, and Arnold, and founded the firm's HIPAA practice group. Ken, thanks for joining us. It's a pleasure to have you on.
Thank you.
Ken is joined by Mary Mack, as I said, an attorney and strategic advisor for some of the largest products liability class actions, internal and government investigations, and antitrust and IP disputes. Enterprise Technology Counsel at ZyLAB. Mary's clients include the largest law firms, pharmaceutical companies, and insurance companies in the world. She is one of the leading speakers and authors on electronic discovery issues, technology, and the law. And I'm sure most of you know she's very good at this. She's done a bunch of these web seminars. She's also a co-author of the popular book, A Process of Illumination, The Practical Guide to Electronic Discovery. Mary, it's good to be with you again. Thanks for being here.
It's great to be back. Thanks, Robert.
And last but not least, we have Johannes Scholtes, Chairman and Chief Strategy Officer of ZyLAB. Jan was the company's president and CEO from 1989 to 2009 and shaped ZyLAB into an information management powerhouse in countries across the globe. His leadership and vision led to ZyLAB being selected for historic and high-profile engagements, including the United Nations War Crime Tribunals, FBI Enron investigations, and the United States White House Executive Office of the President. Before joining ZyLAB, Jan was a lieutenant in the Intelligence Department of the Royal Dutch Navy. He is also on the board of directors of AIM, the worldwide leading authority for standards in education and enterprise information management. Jan, welcome.
Thank you. Thank you. Very happy to be here.
All right. Well, thank you all again. Before we get started, I want to remind attendees to type your questions in the chat box on the right of your screen, and we will get to them at the end of the presentation if time allows. Okay, Mary, my spiel is over. It's all yours.
Oh, great. Thanks, Robert, for that wonderful introduction. I'm absolutely floored that we have listeners in the heat of the summer coming to listen to what is going to be one of the hottest topics moving forward this year, and that's the changes in the HIPAA laws. I think it's something that's sneaking up on most of us, but not Ken and not Jan. They've been working in this area for many, many years, and they're going to bring their global and their U.S. Experience to bear on this webcast to give you a head start on all of your colleagues on exactly what is required under these new HIPAA laws. I know for myself, as we prepared this seminar, I learned quite a bit because I had many, many misconceptions about what was covered, what wasn't covered, who had to pay attention to this, what kind of reporting, what kind of penalties, the whole thing about business associates, and then also what was really interesting is that we had ZyLAB introduced, as a surprise to me, some very interesting technology to get a really big jump on this. So that's we're going to be talking about all of this, and I think, Ken, in your when you take the reins here, you'll also give those of us on the webcast some tips about how to look at this as a career enhancement as well. So Ken, thanks very much for agreeing to do this with us, and we'll start with your 3 hottest issues for the hot summer webcast.
Thanks, Mary, and that's certainly appropriate. Here in Manhattan, the temperature is expected to reach near 100 today with almost 70% humidity. So no, this is not the Weather Channel, but I just thought I would throw that in for this particular theme. Most of you know that the HIPAA rules, the HIPAA privacy and security rules, took effect in 2003 and 2004, but it's only been in the last several years that enforcement has particularly ramped up, and this has come in tandem with advances in health information technology and health information governance. To put it bluntly, there is a lot more information out there, and it is a lot easier to lose. It is a lot easier to misplace and have fall into the wrong hands, and it is a lot easier to alter, either unintentionally or intentionally. The other thing that's happened this year, and it is literally a sea change in the healthcare environment, is that perhaps with all of the attention on the Affordable Care Act, which most people know as Obamacare, taking effect in January, there were significant revisions to the HIPAA privacy and security rules, mostly the security rule, in March of this year. And to anticipate a question that may come in, as Mary was kind enough to alert me to earlier, these rules are in effect. Enforcement on the new rules will start in September, and it is not affected by the pushback of 1 year in the employer mandate in the Affordable Care Act. In other words, this is here now, and it affects a much broader swath of organizations. We have on the screen now the 3 hottest issues in the revised rules, which are cybersecurity, information governance, and essentially how to take all of this information that is proliferating at a geometric level and write it safely to enhancement of quality of care and control of costs. The 4 things that really came into focus and have changed dramatically since March are the definitions of those who are covered under HIPAA, the definition of business associates, those who are performing services for healthcare providers and health plans that requires the regular access to patient treatment and identification information, has been expanded to do 2 things. One is to make business associates under the direct jurisdiction of the Department of Health and Human Services, and thereby amenable to investigation and perhaps even administrative prosecution for fines for violation. Second is the expansion of the business associates to include subcontractors, those to whom the business associates send protected health information for use to be able to do a task that the business associate requires. There is not only now coverage for those subcontractors, there is a requirement for a written agreement between the subcontractor and the business associate. Law firms are business associates if they are performing a service that requires them to have access to patient records. And I use the term patient records very broadly. It includes billing information, it includes emails, texts, social media posts, blog posts, any kind of communication that can be traced back to an identifiable patient. The third thing that has changed is the definition of a breach of confidentiality, a breach of security. The bar has been lowered. It has been lowered. It was under the previous rule, there was a threshold that a breach of information was not reportable, perhaps not even actionable, unless there was a significant risk of harm to the patient. That threshold is gone. The new standard presumes a risk of harm and puts the burden on the entity that lost the information or permitted a breach of that information to prove that there is no risk of harm. And there is a 5-factor test that is somewhat difficult to meet. So those are the 3 changes, and the corollary to that is the 4th one, which is that enforcement has been ramped up dramatically. Under the new rule, this was part of the stimulus package in 2009, but it was finally codified only this year into the HIPAA Final Rules. State attorneys general may now bring HIPAA proceedings if the Office for Civil Rights of the Department of Health and Human Services, which is the entity charged with enforcement, declines to proceed. Some attorneys general have already taken advantage of this, specifically Connecticut and Illinois. Those are the 2 that I'm most familiar with. I'm sure there are others. Also, being on the number of listservs as I am from the Department of Health and Human Services, I can tell you that they have been advertising for enforcement personnel. For those of you who are familiar with the sequester, this may come as a surprise. You may have thought that there was a hiring freeze across the board in the federal government. Well, this is an exception. And think about it in thematic terms, and you'll understand why, which is that electronic, can you flip to the next slide, Mary? Electronic health records are a linchpin to the revision of health care information governance in the United States. That linchpin is that it will be much easier for the government to keep track of quality of care metrics, quality of cost metrics, because of 2 things. One is, in that stimulus package I mentioned earlier, was something called the HITECH Act. HITECH stood for Health Information Technology for Economic and Clinical Health. Now, that didn't start life with that name. It started life as HITECH, and then someone figured out what the acronym should stand for. This is how government names statutes and programs on a regular basis. But in that was a $27 billion subsidy, if you will, to bring hospitals and physicians and physicians groups and ambulatory centers into a fully interoperable electronic medical record system by 2015. Now, hospitals were could be eligible for grants of between $2 and $10 million each, depending on their Medicare and Medicaid share in the patient population. To assist them in making this conversion, doctors between $44,000 and $65,000 each. Again, same thing. So there was a lot of money involved here, and part of the rules for obtaining that money is to meet certain criteria in a set of requirements called the meaningful use rule. Part of those criteria, and one of the things I do is I work with hospitals and physicians groups on compliance issues with their electronic medical records as well. Mary, go back to the previous slide, if you would. Thank you. Now the one before that. The one before that. Yeah, perfect. Thank you. Some of those criteria specifically refer to the HIPAA security rule, and they talk about the ability to maintain and communicate patient information in a form that requires that meets the requirements of the security rule. So there's skin in the game here. There are dollars at stake in compliance. You know, when I started this practice in 2001, 2002, the very early days of HIPAA, you know, there was a great fear that if people weren't fully compliant by 2003, the HIPAA police would come and descend on the hospital or the doctor's office. Well, that didn't happen because there was not a great interest in compliance under the Bush administration, and that changed radically in the Obama administration. But now there is actual money at stake. If you don't meet your security compliance requirements, you may not get your share of that $27 billion. Or put another way, if you do certify that you have met those requirements and you have not, if you have had a security breach, or if you have been audited and the government is starting compliance audits for this money and you are found to be lacking, not only will you not get the money, but you may pay significant amounts of money in legal fees and perhaps in fines, and this is a very big deal. So security is top of mind now. Also, remember, the public is very interested in security, and because of the importance of electronic health records to the success of Obamacare, it's critical to the federal government that the public have confidence in the electronic health record system. If they don't, because they don't trust it, if they won't give correct and complete information, this foundation here may crumble. So this is kind of the scheme behind the increased enforcement and the partial exemption of the Department of Health and Human Services from the sequester. Now, also, there has, as we've read in the papers, there have been, and seen in the cyber press, hacking is increasing. Now, most HIPAA security breaches are not the result of hacking, but this is going to change and has already been changing because there is a growing black market in personal data. I've spoken with some law enforcement personnel who said that organized crime in certain countries is now finding it more lucrative to trade in personal information than they used to find in narcotics. Imagine that. Data is now the new narcotics. And this is not just from outside the U.S., it's from within the U.S. As well. And for example, there is a class action pending in New York State against a hospital system in which the employees stole identifying information, social security numbers, credit card numbers, and the like, from electronic medical records, also from patient records, and then opened up credit card accounts, opened up bank accounts, etc. And people only found out, the patients found out their information had been stolen that way when they got bills in the thousands of dollars from Best Buy and AT&T and the Apple Online and others. So this is obviously a very, very big deal. Many of the security breaches, though, we're finding are the result of negligence or poor security protocols. Now, the new rules have codified and made much stronger the fact that healthcare providers, health plans, and business associates must have technical, administrative, and physical safeguards for protected health information. Can you go on to the next slide, Mary? Protected health information is, as I said, information about treatment or requests for treatment based on 18 different identifiers, and we'll get to that in a minute. It's not just name, it's not just social security number, it's many different things. Physical safeguards are locks and keys, passwords, safeguarding of information repositories, if you will. Technical safeguards are what they sound like. Encryption, which is a heightened requirement. Communications between caregivers and plans and patients and subscribers must be encrypted, or unless the patient or subscriber specifically acknowledges and consents to have it unencrypted in unencrypted form. And this is a very big deal because those breach requirements that I've been talking about and we'll be talking about a little bit further only pertain to what is called unsecured protected health information. Unsecured information is that which has not been encrypted. The administrative safeguards are getting a lot of attention. That's policies, procedures, and training. The people stuff, if you will. You've heard the term people, process, and technology. That's people and process kind of rolled into one. Business associates now need to have administrative safeguards. They need to have policies, procedures, and proof of training on them that they have taken these steps to safeguard information. In this slide, you will see that a number of the breaches are stolen portable media, lost portable media, and I'm talking about smartphones, tablets, laptops, USB drives that have not been encrypted, or in the case of one particular very well-known proceeding in California, the doctor did all the right things, he thought. He downloaded the charts to work on at home, put them in encrypted format on his laptop, which sounds great so far, but then he put a Post-it note with a decryption key on the bottom of the laptop on a Post-it, and, well, you guessed it, it got stolen. We're also seeing two other very prevalent kinds of breaches. And again, most of this can be dealt with good policy formation, which I'll talk about how the best way to do that is in a moment. We call it the team concept. It takes a team to come up with policies and procedures and safeguards that people will actually use. But the second two things are second bullets here are critical. The use of cloud providers and new applications for the internet and viruses. In the cloud providers, there is a growing trend toward use of the cloud for protected health information. Why? Because the economics are such that you really can't argue with them. You don't need a help desk to the same extent. Updates are provided on a regular basis. Security protocols may be easier to manage, arguably, by a company whose core competency is security. But, and this is one of the things that we do at my firm, we help try to negotiate cloud provider contracts. And yes, you can negotiate them in most instances for our healthcare clients, and make sure they have the appropriate safeguards, security safeguards that comply with HIPAA built into them. There are two recent instances with where providers got in trouble by not doing that, by not making sure that they had the appropriate safeguards in place. One was, and this was actually just a year ago, a cardiology group out in Arizona used a cloud service for their patient calendar so that the doctors who were in multiple campuses and offices all around the Phoenix area, which is very large geographically, could log in and see who had to see which patients where. It was updated from the central office, which was great, except that there was no password protection and it was not encrypted, so anybody who went to the website for this particular cloud provider was able to see which patients were being seen on that particular day, and in some instances what their medical conditions were, what their treatment was going to be on that day. The second, which just happened last week, a very well-known company called WellPoint. You may not be familiar with that name, but they are the umbrella insurance organization for the Blue Cross Blue Shields in many states, the Anthem and HealthLink health insurance companies. was just hit for a $1.7 million fine for and this is interesting because a lot of these proceedings that we see are based on a failure of things like a HIPAA security assessment, risk assessment, which must be done on a regular basis. And then there's a breach. Remember that if there was a breach of information, it's a retrospective analysis by the Department of Health and Human Services. They will then go back and look at your policies and procedures. They will look at your training. They will look at your HIPAA risk assessment and see if it's up to snuff. Well, what happened with WellPoint, oddly enough, is that they had the policies and procedures, but where they were found to be deficient was in implementation. And this showed up because they started with a new database accessible over the internet, but the problem was that there were insufficient safeguards for authorizing those who had access. People who were not supposed to have access were able to get into these particular databases and get such things as full information on treatment, social security numbers, dates of birth, names, pretty much all kinds of protected information from there. The press release and the resolution agreement stated clearly that WellPoint was found not to have implemented appropriate procedures. What that means is that they had them, but they didn't train people appropriately on them according to Health and Human Services, and that they weren't put into action appropriately. So this is a lesson that it's not enough just to have good policies and procedures. You have to have training on them, and they have to actually be put into use. When I get called in to spearhead an initiative at a hospital, the first thing I do is I put together a team that will draft these things, because I'm a lawyer. I'm not a doctor. I'm not a computer engineer. I am not a health information management professional. So what I'll do is facilitate the discussion and bring together a team that has those skill sets. Legal, of course, in-house legal, health information management, which we used to call medical records, IT, and risk management and compliance, and also representatives of the frontline clinical users. And then we will all together put together through my guidance, which is the legal guidance on what's required, sets of policies and procedures that the team will indicate fits that organization's culture and operation, and that people will actually use, and then we'll do training, come up with training materials and provide the training on them. In this way, people take ownership of these policies and procedures. And without that being done, if it's just imposed from on high, it's rarely, in my experience, followed. And I've been involved in healthcare for almost 30 years now. Another area that we're seeing in security is viruses. What happens in this instance is not so much malware over the internet, although we're starting to see that. There were a couple of hospitals recently in Boston where malware was found in implantable medical devices. Now, this is really scary stuff. It's almost like science fiction, because security protections had not been updated for the electronic health record system, and viruses and other malware were introduced and actually got into some of the medical equipment and some of the implantable devices. Fortunately, nobody was injured because it was picked up in time. Law firms in the New York area have been hacked, and in the Toronto area significantly, and also the subject of viruses as well, as the FBI found in a report they did 2 years ago. But one particular hospital in Georgia was forced to transfer all non-emergency patients for 3 days because a physician took home some charts on a USB to be finished at home, and then plugged the USB into his home computer, where one of his children had clicked on the wrong attachment earlier and got a virus. He then went back to the hospital to re-upload the charts from the USB, and you can guess what happened. What happened after that? Could we go to the next slide? Okay, so we talked about some of the obligations under under HIPAA and the HITECH Act and the Meaningful Use Rule. I want to point out one other called minimum necessary, and this gets a lot of attention, has gotten a lot of attention lately, and will get even more attention, although outside the United States, when Kate Middleton gives birth, because this just came up recently with Kim Kardashian's birth. There, short 3 days after that, Cedars-Sinai Hospital in Los Angeles found that 5 employees had left what's called a cyber trail, an audit trail, that they had gone into medical records they had no authorization to look into. The articles did not say whether it was Kim Kardashian's records or not, although there was a high degree of suspicion that they were. Hospitals in California have had a particular problem with employees snooping into celebrities' medical records. We've had that in the New York area as well. That is a rank HIPAA violation. UCLA got hit for a very large fine 2 years ago for that, and Jan is going to talk about some software that can help detect a pattern that can come to that. One other thing to realize as well when you're doing your HIPAA security analysis and your HIPAA protocols is don't forget about state laws. State laws that are stricter than HIPAA do survive and are not superseded or preempted by HIPAA. And there are many, many states that have them. Massachusetts and California have some of the strictest state laws. They go well beyond HIPAA. And even though you may be compliant with HIPAA, if you're not compliant with state laws on privacy and security, the state can come in as well. So something to be particularly careful about. Some of the larger fines in this area and greatest adverse publicity have come from state laws and state issues. There are legal benefits as well, and Mary's going to talk about the information governance aspect for eDiscovery and health information, but strong security practices can make your health information easier to get admitted in court. My career has largely been spent before I became a compliance lawyer in the early 2000s as a trial lawyer, both civil and criminal. To get any sort of electronic information admitted in court requires a number of foundational hoops to jump through, 2 of which are authentication and chain of custody. Authentication is that the records is what you say it is, and the second, chain of custody, is a form of reliability. Can the court trust the information? Has it been kept in a form in which it has not been altered? Can you prove that as the proponent of that information that it's in the same condition it was when it was created? Strong security protocols that show that no one other than authorized people can get into these data go a very long way in that regard. I have a law review article I wrote on this topic. If anyone is interested, you can send me an email, and I will be happy to send you a PDF of the article. But suffice it to say that the use of electronic evidence is relatively new. The courts are still unfamiliar with it. They will default to some rules of evidence that we have not heard about since law school in that regard, and you have to be ready as the proponent or opponent to either be able to support the evidence or know how to challenge it. Next slide. There are also requirements in the Affordable Care Act for electronic information to have integrity and to be able to be accessed quickly. Section 104, for example, talks about eligibility inquiries being electronic and being auditable and reportable. Remember, there's going to be close to 40 million new insurance subscribers over the next 2 years, and that's fairly critical. I talked about skin in the game. Look at the upper bullets, that if you're not compliant with the meaningful use rule, including HIPAA security, by 2015 your Medicare and Medicaid reimbursement will be cut. In where I practice in New York City, some hospitals get 80% of their revenue. for Medicare and Medicaid. And there is a 2-year look back from 2015, which means that to avoid the penalties, your institution, your organization must be compliant by the end of this year. So there is a lot to do in a very short period of time between now and the end of the year, but it is manageable with the appropriate personnel, the appropriate guidance, and certainly the appropriate guideposts, including leveraging what the organization already has in terms of trying to bring it about to a fully compliant scheme by the end of this year. Next slide. The standard for reportable breaches and business associate agreements have been, we've discussed that. I'm just going to mention very briefly that there are new requirements for HIPAA business associate agreements between business associates like law firms and consultancies and IT organizations and billing and coding institutions, those that are not already covered entities, and vendors between them and the providers and plans, and between their subcontractors as well. These all need to be rewritten to have the new provisions in mind, including new standards for reportable breaches. The way a breach is reported, by the way, is that if it's by a business associate, it must be reported to the covered entity, the plan or the provider, which then in turn must notify the patients, and if more than 500 patients are involved, they must notify the media. Nobody wants that to happen. Next slide. Okay, Mary, do you want to start off on the discovery issues, or would you like me to?
No, I think that's fine. Thanks, Ken, for walking us through the HIPAA issues. One of the surprising things for me was the requirement that the business associates not only have contractual provisions, but also have a process of, as Ken said, to do reporting. And reporting up. And so what struck me, Ken, was that they'll probably, like there was earlier a few years ago, some counsel convergence around eDiscovery. I think that organizations probably will not want to reinvent the wheel with many, many different service provider business associates, and so I think there'll be some narrowing of where they may have many providers, that there will be some fallout for those who aren't quick on the uptake for these new rules and procedures, and the teamwork and trust that's required for those things. So in terms of eDiscovery, we've been working with things like audit trails, but one of the things in IT that happens quite a bit is that audit trails are written over. You know, they're kept for a certain amount of time, and then they're gone. And so, in terms of eDiscovery and in terms of compliance, looking at audit trails and perhaps looking at the records management aspect and how long those need to be kept and where they might need to be kept so that they can be used. The other thing I think that our eDiscovery systems in our eDiscovery community, the use of them for various electronic communications to take a look at things like blogs, social media, some of the publicly available material, and then also within emails, taking a look at various emails to see how often does staff actually include a medical record identifier in an email. It's much more common than one might think, even though it's not supposed to happen. So you know, as Ken said, the health care organizations are just getting their act together, and so those of us on the call who know how to do data maps, there is a process, as Ken has described, that's much like assembling an eDiscovery team to assemble the HIPAA team, and many of the same people will be involved. When we first started talking about the HIPAA changes, I was very concerned about what about communications from employees that were asking about disability pay, or if somebody said, you know, I need to be out for a couple of days because I have a particular medical condition. Were these things covered? What about wellness programs that are gathering information about the current state of a person's health, and then communications around that? And Ken, would you like to talk a little bit about a covered entity employment considerations before we move on to the technical?
Yeah, this is a bit of a gray area, and there are some complexities here, so I'll touch on them a bit. As I said before, protected health information is treatment or requests for treatment traceable to an identifiable patient. Now, there is an exception for certain employment-related examinations, things like drug tests, for example, or employment physicals, and those are not considered protected health information. But that said, here's where the complications come in. If your entity is if your organization is such that the person who considers the requests for sick pay, disability, family medical leave, and the like, is also the same person either who determines promotions or hiring or firing, there may be a difficulty in proving that someone's medical condition did not play a role if you don't have appropriate policies and procedures to state that these things are not taken into consideration. That's, you know, there have been, and I wrote on this a few years ago as well, employment actions brought on that very issue, that these things were improperly considered because the benefits administrator is also the office administrator who works in turn with the CEO or head of the firm, as the case may be. The second aspect of it is what happens when employees go for treatment at one of their employer's facilities, say an on-site clinic, for example, or a hospital, where and there have been a number of privacy-related lawsuits in New York State where nurses and physicians went for treatment in their own hospitals only to find out that their information had been disseminated, talked about, sent around electronically or otherwise, to their coworkers. That is clearly a HIPAA violation. This is where risk management, IT, and counsel really need to work together in making sure that they've set up appropriate walls for this information, and making sure that it doesn't go where it's not supposed to go, and finally that the technology is in place to make sure that there are suitable dashboards for risk and compliance and IT to monitor patterns and trends that could show that this information may be disclosed to or accessed by people who didn't have a business reason to look for it, because that's what the minimum necessary edict in HIPAA is all about. If you could sum it up in one sentence, it's don't use or disclose or view medical information without the patient's consent or a significant business reason to do so.
So with all of the technology and the information that's out there, Jan has been gracious enough to put together some slides that very clearly delineate what the information is, and then how technology can help surface this type of information so that the legal and risk professionals can take a look at it and determine exactly what to do with it. And if you don't know what you have, you can't do anything with it. So Jan, will you talk a little bit about how technology can assist in this endeavor?
Yeah, no, absolutely. Now, what you see here is a list of 18 very concrete identifiers that can be linked to protected health information, and that must be treated with very special care. Of course, there's names. There's very specific type of geographical identifiers. Actually, it's everything except for like the state identifiers and the initial 3 digits of a zip code. Dates directly related to an individual, like birth dates or other types of dates. Phone numbers, fax numbers, email numbers, of course, social security numbers, medical record numbers, health insurance beneficiary numbers, account numbers, license numbers. And of course, very important, all kind of biometric identifiers, information, images, and of course, any type of disease, treatment, or anything else that's related to a patient. So this is a very clear list, and as you said, Mary, it starts by identifying where this type of data is. Because only if you know where it is, you can take appropriate action, or you can do auditing on the security settings of that particular locations. What you see in a lot of hospitals and a lot of medical centers is that because of the ongoing electronic storage of data, a lot of this data is all over the place. And what's actually very interesting is what we see is that the only data that typically these institutions care about is the data of very known persons like celebrities. What we see is that in general they take a little bit more care with that type of information, but if you're just an ordinary individual, it could be that your information is anywhere on hard disks, printer caches, bring your own devices, maybe iPhones, iPads, whatever, and a lot of times users are not even aware that this information is actually accidentally or because of computational reasons stored on different devices. So if you take me to the next slide, Mary, what we do typically is we first want to identify where this information is, and what we've done is we have created a number of libraries with analytical processors that are able to identify particular information related to HIPAA, like protected health information. And then this is part of a larger effort that we do also to recognize personal identifiable information in general, or FCPA, bribery, antitrust, or other type of information, or legally privileged information. So it's part of a larger technological capability that we have, and what we did is we created a specialized library for detecting protected health information, so healthcare organizations can actually use this to identify where this type of data might be in their organization. Next slide, please, Mary. I'll show some examples. This is, for instance, an example of how to recognize Social Security numbers. Social Security numbers are pretty easy to recognize. They have a very specific format. The big problem with Social Security numbers is that they may occur in images, in PDFs that are non-searchable, or they may be hidden in other electronic formats, or they may be hidden in revisions. So they're not always electronically, like on the outermost surface. But there's many different ways to find them. And what we do is we find these type of Social Security numbers, we highlight them, and we can create reporting. If you take me to the next slide, I have a couple of other examples. What you see here, this is actually brand new. This is technology we recently built into our eDiscovery platform. What we're able to do is we're able to do what we call visual classification. We have teached a number of images to a computer program, and use machine learning and artificial intelligence to recognize different type of images. And for instance, we can recognize images that are very probable IDs, like passports, ID cards, driver licenses. So instead of looking at the text, the computer recognizes these images by looking at very specific features, very similar to how we humans would recognize an ID from a distance. And we can do this for a lot of different types of images. We can also recognize indoor, outdoor images of people, faces, young people, old people, cars, helicopters, weapon systems, electronic devices, whatever. And one of the visual classes we can automatically recognize are IDs, and this can be very useful to identify copies of IDs that are made and stored somewhere in a computer system. On the next slide, there's a couple of other examples. What we have here is actually some data. You may all be aware of the fact that the ENRON data is made available to the general public. And what we've done is we've been looking in a recent collection of that data, which was processed and supposedly it was removed of personal identifiable information. We actually looked for a number of protected health information, and we found this form. Fortunately, it was an empty form, so there's no real health or information filled in. But you can see that with our technology, we can easily detect this type of forms and assess whether it's a violation of a protected health information or not. And this is actually still a form which is in the pre-processed ENRON collection. On the next one, I show you a couple of the patterns and the words that we look for diseases, disorders. We use a special type of search for this. We call it a quorum search. It's a search that's doing a combination of an and and an or, but it also has like a certain threshold value. So we can look for a bucket of words, and then between all those words we do ors. But we can set like a threshold, like 2, 3, or 4, meaning that at least 2, 3, or 4 of those words have to occur in the document, regardless which one it is. And that allows you to make a perfect combination between precision and recall, and you don't suffer too much from too many false positives. Now, on the next slide, you actually see some pretty shocking information. We actually redacted it. But this is still in the ENRON set. It was that a certain individual, Mr. X, I redacted his name, has skin cancer, and he was planned for operation. This is in just a standard email. This is the type of information that is not very much to the surface. And this may be the type of information that is protecting the rights of your of patients, and that can result in severe lawsuits or class acts. On the next slide, you see a couple of other technology tools that we have. Because when you're going to look for protected health information, you also need to have like a tool to review it, to see whether there are in fact false positives or false negatives, and to assess whether the information is actually a violation of HIPAA or protected health information regulations or not. Now, what we typically use for this is the same interface we use for our eDiscovery legal review, making it very, very easy and very efficient to review a large data set with a group of people. For quality, we can use sampling, so you don't have to review everything, but you could just review like 5 or 10% and then extrapolate that result to the larger set of the collection. You can take different types of actions. You can remove the data, or you can move it to another location, or where there's better protection, or you can change the security settings. Whatever you feel or think or have to do, which is appropriate to be compliant with the HIPAA regulations. Now, on the next slide, one of the other things now is, suppose that you do have to disclose this type of information for eDiscovery reasons. Then we also have technology which allows you to automatically and manually redact information. If it has to be disclosed to third parties, and the document is responsive, but it does contain certain elements that are being considered as protected health information, we can redact them. And on the next slide you see a couple of examples. We can do this not just in like Roman languages, such as with a Roman character set like English, but we can also do this in Korean, Chinese, Japanese, Arabic. We can even do it in different directions if you happen to have text which goes, many different directions. This is something you see a lot on medical documentation, where you have drugs, and then on the additional information on how to use it, you often see that the text is printed in many different directions because they want to fit as much text in small print as possible on a piece of paper. So we can deal with all of that type of information. On the next slide, you can even see that some examples of how we can find like all these different components of protected health information, such as zip codes, phone numbers, titles, dates, names, license plates, and it doesn't really matter whether it's like US or overseas information from Europe or from the Far East. We can recognize hundreds of these different type of patterns and make these documents, mark these documents for being potentially violating HIPAA or containing protected health information. Okay, next slide please, Mary. So how do we market this? Now, we sell this as part of our software. We have a very complete eDiscovery on-premise end-to-end system, which can also be integrated into your information systems. We can connect to hundreds of different repositories, including email, SharePoint, file systems, but also many other systems that are used to archive content management systems, ERM systems, CRM systems, and behind your firewall we can create like a full solution to solve this. You can also connect them to cloud systems, like what Ken said, a lot of data stored in the cloud or social media. We can connect to almost all of those, the most popular systems. It's also possible to rent our software. In that case, you don't have to buy the full license, but we have a volume-based solution that allows you to log into a virtually fully equipped war room, pre-configured with your data, or you can upload your data yourself. And we can even create a private cloud for you if that's what you wish, where we install our software exclusively for you in a private cloud, so you have optimal security and encryption, and you're compliant with whatever security requirements exist in your case. Okay, and that was the technology part. I hand it over to you, Mary.
Thanks, Jan. We've got a couple of questions, and as we're answering questions, I'll leave the white paper that you have written up on privacy and data protection. Some of those slides that you showed with the regular expressions were pretty dense, and so I think it would be good for folks to have something written there. And then, so you can get that by sending an email to Annalore, and her email is on the screen there, and Ken has graciously offered to send his white paper, and you can email Ken or send a note to Annalore, and Annalore will email Ken and ask him to send you the paper. So some of the questions that we have, I have one on that says that this looking at protected health information and auditing looks a little bit like what people do for defensible deletion in taking a snapshot of, say, a file share or some email or another data source to see which data falls into various categories to keep, purge, or otherwise. Are either of you seeing the data deletion or defensible deletion initiatives being expanded to also look for the incidence of protected health information or personally identifiable information?
Well, let me start off by saying all almost all information in a healthcare provider or a health plan that refers to patients and treatment is going to be protected information. So you don't necessarily have to look for it per se. Where the technology Jan was talking about and some others that I've seen come into play is it being sent where it shouldn't go? And is there technology to show where it has gone and to monitor what appear to look like patterns of too much information going to one particular source or too many records being accessed by one group of persons or one individual? And in that sense, I've seen that kind of technology being put to use to create dashboards that the risk management people can monitor for that in that regard. It's less a function of deletion because there's a requirement in HIPAA, as there are in many state laws, for maintaining information for certain periods of time. It's 7 years under HIPAA. So that becomes less of an issue unless, of course, you've got a litigation hold coming into effect, and then you have questions of whether non-medical record information on stuff outside the formal chart, like emails and texts and the like, are possibly being lost. That's where you need your litigation hold protocol.
Yeah, well, what I would like to add is that like in defensible deletion, the decisions you make and also the information you have to extract are all related to a filing plan. If you have a filing plan, every part of your filing plan is sort of retention policy. So what you would look for in defensible deletion is for classifications that classify a document into a part of your filing plan, and then depending on where it's being classified in your filing plan, you can decide whether the document needs to be transferred, retained, or just kept. In this case, with protected health information, you are primarily looking for information that accidentally or deliberately or for valid or non-valid reasons contains protected health information without you. And then of course the parts where you find it where you wouldn't expect it, it is actually the most interesting data. Now I think in general it's very clear under HIPAA and protected health information what you need to look for. So you can immediately start doing this with the libraries that we created. If you want to use this technology for defensible deletion, you can also use it, but you do need to create a filing plan first. And what I've seen in real life is that a lot of organizations do not have a complete or up-to-date filing plan. And I wrote actually a couple of books on it, on how to create a filing plan then. And also how to use similar technology in a process of defensible deletion or intelligent cloud migration or legacy data cleanup, whatever you want to call it.
Yeah, and the other question, thank you. The other question I have is, in your experience, Ken and Jan, how many law firms and how many service providers and consultants do you think are ready for these new HIPAA rules?
Well, not too many, although they are becoming more and more prevalent because those who employ them, those who retain them, are requiring that sort of compliance. In fact, I'm special HIPAA counsel to a number of law firms here in New York, and I was brought in on some engagements recently because their client hospital systems insisted on it. Insisted that they have written policies and procedures that were updated to reflect the current changes in the law, have the appropriate agreements, and have training on those protocols. So it's being client-driven in that way, and it is increasing.
Yeah, no, I fully agree with that. Yeah, that's also what I see. It's like 100% client-driven, and then it's the hospitals and the organizations and the corporations that see the risk, and they want to take actions, and that's when they involve service providers and law firms to help them. Yeah.
There's also a new due diligence requirement in the HIPAA revision that took effect in March, which is that there is an element in there that the covered entity really has to look into whether or not their business associate is compliant and can be found responsible for the breach by the business associate if they have not done their homework to find out what level of compliance that business associate has.
Interesting. Now, Robert, do you have other questions?
Yeah, I actually have a question for Ken. Ken, you mentioned that stolen portable media is often the source of some of these security breaches. I'm wondering if you're seeing that service providers typically have BYOD policies in place, and if not, how you advise them in that regard.
Most of them do have BYOD policies, particularly the hospitals, which are employing large numbers of younger people as medical residents, nursing technicians, IT, that sort of thing. That it almost becomes a hiring imperative to have a BYOD practice. And I write some of the policies for these organizations on BYOD and security. And some organizations want to approve the device as they see it. Some are too large and approve the settings, the security settings. Some provide their own apps. Some are too large to do that or just don't want to be bothered with it and feel that they can do it just on a policy basis.
All right, great, Ken. Unfortunately, we're out of time, but I'd like to thank all three of you for a fantastic presentation. Great job.
Thank you. Thanks, Robert.
Great. Thank you very much. It was a pleasure.
And just a reminder to our attendees, if for whatever reason you missed part of the presentation, it will be posted to our site under the training tab in the next couple of days. We'll also post the complimentary white paper from